We will proceed with the third case on the docket. It is from Douglas County, number 127701, entitled The State of Kansas versus Darren L. Henry. Who do we have here for the appellant?
Dylan Pryor, Assistant Appellate Defender, appearing on behalf of Darren Henry.
And for the appellee?
May it please the court, the state appears by Senior Assistant District Attorney John Simpson.
All right. Mr. Pryor, you can begin, and do you wish to reserve any time for rebuttal?
Yes, Your Honor, if I could have 3 minutes for rebuttal.
That is granted.
Thank you.
Whenever you're ready.
May it please the court. The district court appointed Adam Hall to defend Darren Henry in the fall of 2020. Hall represented Mr. Henry for around a year and a half, with the district court granting substantial motions to suppress evidence during that time frame. Then, a jailhouse informant provided the state with a basis to seize and search every last piece of privileged material Mr. Henry possessed. Following that search, the state moved the district court to remove Hall as Mr. Henry's attorney, attaching nothing more than a privileged investigative report in support. Despite the district court finding that this report was work product, it nonetheless granted the state's motion, finding that Mr. Henry's interest and Hall's interest may at some point conflict.
Well, let me stop you there with the question. Hall was removed in the March of 2022. Is that right?
That's correct.
And then about a year later, Mr. Henry has a motion to suppress, and Hall testified as a witness in that case. How would that have worked if he was still a counsel of record?
Well, so in that case, because that was a motion to dismiss the case based on the state's seizure and search of his materials, I think it would have been more than fine to just have Mr. Henry testify, like pursuant to Simmons, saying, yes, these are all because the issue there was, did these documents contain communications between Mr. Henry and Hall?
It was Mr. Henry's motion to suppress that evidence.
Well, there was a lot in that motion, but like it was primarily Mr. Henry moved to dismiss the case because the state's seizure and search of his materials had so prejudiced him that he didn't believe that.
Well, I guess my question is, if it was important enough for Mr. Henry to call Mr. Hall as a witness in this very important hearing, doesn't that kind of show that Hall couldn't have really possibly stayed on as counsel in this case?
No, Your Honor. At that point, I believe it's belt and suspenders because, I mean, at that point, Hall was already off, so he was available as a witness. I think Mr. Henry could have gotten just the same amount of evidence. It would have been the same if it was just him testifying that, yes, everything the state seized and it searched, that was all of the materials I possessed. It was all my work product. It had all my communications between me and Mr. Hall. So it wasn't cumulative, but it was corroborative. So he wasn't a necessary witness in that.
Well, the court also, if I understand correctly, removed the lead prosecutor in the case, correct?
That's correct.
So defense counsel's gone, lead prosecutor's gone. The court seemed to find the district attorney's procedures were lacking in several details. So what other remedy did the court have before it?
I believe the proper remedy was that it should have disqualified the Douglas County District Attorney's Office.
Now, why? Tell us why, because that's a big office, isn't it?
I don't know the exact number of attorneys there, but it's, I'd say standard size, probably a bigger county. But that would be consistent with how our Supreme Court has dealt with an adversary, like a party, like a member of a firm obtaining an adversary's confidential and material information. We have imputed disqualification.
The court went through a lot of this, and he said, recommended that they get the Attorney General's office to prosecute or get a special prosecutor, correct?
Yeah, and I believe, I can't remember the volume, but I know that Douglas County informed the district court that it had reached out to the attorney generals twice. They had said no in taking this prosecution. They reached out to Shawnee County, Johnson County, Wyandotte County. All of them had said, no, we're not taking this case. And so at that point, again, if they didn't want to, I mean, if the district court had disqualified Douglas County, then perhaps the attorney generals or another county would have been more likely to step in. But because Douglas County was going on, well, I don't know what they said, but there was no reason for another county to come in. But it would not have been too much to have another county come in. We have the attorney generals, we have the major crimes unit. They come in and handle cases for counties all the time. Here we see, I wasn't aware of this till this case, that counties will do reciprocal prosecutions. And so the idea that another county or the attorney general's office would step in to handle this prosecution isn't out of the ordinary.
This case, though, is out of the ordinary. Wouldn't you agree? I mean, we don't really have any precedent on imputed knowledge to attorneys that's directly applicable, because the cases you've cited are more when you have sequential representation, correct?
You're absolutely correct. And so I don't want to say I was flying blind, but that's why I believed it was a proper synthesis of everything following the adoption of Rule 1.10. Now I know we have Minnelli and I know we have comment 6 in 1.10. If this was, for example, like Dakota Loomis is now the district attorney there, comment 6 would say that, because he represented Mr. Henry in private practice, that imputed disqualification isn't there. We don't, and simply like a public defender that's, government going to government, that's not here either. And so that would be fine, but we don't have that here. What we have here, and this is my entire theory, is that when a member of a firm, and prosecutors' offices are firms, obtains confidential and material information of an adversary, then the proper remedy is to disqualify that firm.
What's your authority for branding the district attorney's office as a firm?
So the most recent is State versus Miller from our Supreme Court, where it reiterated what it already said, that under Rule 1.10, where we get imputed disqualification, a prosecutor's office is a firm. We also have the Wong case from 1989. We know that public defenders' offices are firms, and under Rule 1.10.
If my count is correct, there's like 12 attorneys from the district attorney's office had access to this information.
The district court was ultimately not able to tell how many people had access or could access it or even had accessed it based on the evidence.
What procedures did the district attorney's office use to segregate this or protect this privileged material?
None.
Didn't they have a taint team or some way of sort of screening people out and not letting them have access to certain the documents that are at issue here?
They did, but again, we don't have these screening devices. The Kansas Rules of Professional Conduct, I guess, good lesson for the what else is that we don't have screening devices in Kansas. In other states, we might be able to say, this prosecutor, you go and look through it and we'll just wall you off. We don't have that here in Kansas. Moreover, it wasn't proper for the state to be the one to search through it to find whether or not there were privileged materials. Our discovery statute specifically says it's the district court who determines whether something is privileged or not. And that was the purpose why Verona was there, because Rob, the police detective, or the police officer, and Nicholson, the detective, they wouldn't know what's privileged from what's not. So they used an ADA to be the one to make that determination. Statute doesn't contemplate that. Moreover, it's improper to have your adversary be the one to determine, whether something might be privileged or not. You don't want that bias. You want it to be before a district court who's neutral and detached. In some of these cases that I cited, although I didn't sign for these propositions, what happens in these cases is that the state will go and they will seize the materials, then they turn it over to the district court. And oftentimes the district court will then give it to a different district court judge. So the district court's not tainted by what it might see and say, pluck out what's privileged, what's work product, what the state shouldn't have, and then give everything back. Then we can hand it over, because then we're not worried about any sort of discovery violations or the state not having something that it shouldn't, something that's protected by discovery. And then it can go through pursuant to search warrant to find anything that Mr. Henry shouldn't have had.
Let me ask you this. Did your client receive a fair trial?
I do not believe so. And I think that's what kind of goes more to my second issue, because what I think what we're dealing here, well, I guess they go to both issues, because we ultimately can't trust, I don't want to say well, I will say the legitimacy of it, because it's different from harmless error, where we can say, where there's the erroneous admission of evidence, and we can pluck that out and say, well, if that hadn't come in, everything else was fair. Here, after, with the imputed knowledge, once that information had gone into the Douglas County District Attorney's Office, we don't know how their prosecution was shaped by that. There's simply there's no way to know.
Or is it speculation to say it was shaped by it at all? What's the prejudice?
I think so, and that's what we see in a lot of cases. They say the defendant has to come forward and point and say, here's where here's what the state got that they.
Well, did they use this information to disqualify defense counsel?
They absolutely did. And I think that's correct, but I was also wondering about the trial. How can we know whether it's a fair trial? And there's just no way for Mr. Henry to know how that knowledge would have shaped the prosecution. Like, I think of an analogy, say, four of us were playing cards all night, and Judge Gardner, you and I are across from each other, and I keep beating you. And once you're out of chips, you stand up, turn around, and you got to see there's a mirror behind you. And I was able to see every hand you had. And you say, you use that knowledge to beat me. And I tell you, show me how. Show me which hands I played that, were based on what I knew. You can't do that because I kept my cards close to my vest. You never got to see, what I was playing with, what I had. And so it is, I think, an impossible standards for defendants to be able to point to a specific instance of, here's how this question was, affected by what the state learned. And that's the problem. I think it just goes throughout the entire prosecution. Once they see that confidential material, it's just impossible to know how it didn't affect the
I've got a
trial.
question about your second issue.
Sure, and I see we're getting under a minute.
Yeah, and that makes me crazy when it goes real fast like that. So I'm going to not
Yeah,
try to
I'll-
look at it.
Okay.
What are we to do on that? I mean, that we're presented with a fait accompli. Or do you want us to give you an advisory of opinion that we would not have dismissed defense counsel?
Uh,
Do we approve it? So what's the practical effect of that? Aren't you asking us for an advisory opinion?
No, absolutely not. What we'd say is that it was an erroneous decision to disqualify Hall. And when you disqualify counsel of one's choice, that is structural error. So the proper remedy would be reverse and remand. And I haven't talked to Mr. Hall, but it seems like it'd be proper to put him on, because that seems to be the whole issue here. We don't know how the rest of pretrial would have went. We don't know how the rest of trial would have went. I see I'm out of time. If I can.
Don't worry about that. You can still win this, though,
Oh,
even if we find that it was okay to remove Mr. Hall.
mhm.
And your winning argument would be they should have disqualified the entire
Yeah, I
county attorney's office.
that's correct. I have two ways to victory. Like, there were two errors of such magnitude that either one would require reversal. And so, yes, if you find for me on the first, I don't think you have to find for me on the second. You can avoid the, saying whether he had the right of continuing representation under the Sixth Amendment. But
And you're not waiving your third argument?
no, absolutely. I'm sure this court is more than familiar and capable of handling whether an eyewitness identification should be suppressed. It's bailiwick, whereas these are more novel issues. So that's why I wanted to focus mainly on those. I am out of time. I want to respect the court's time unless it has any further questions.
I'm seeing none.
Oh, thank you very much.
May it please the court. As this court is aware, the parties have argued a number of things in their briefs, but
I've got a question for you, counsel.
Sure.
Did you participate in this trial? Were you one of the 12 or 13 of the DAs that saw this material?
so I'll answer your question, then I have an additional something to add, I guess. I didn't hear about this case until I received the brief. And receiving the brief and looking through the record, I don't think it's fair to say that there was anything evidence of anything more than 5 people having had some exposure to the confidential information in this
As
case.
I understand it, the information was put into a computer, some sort of computer record.
So the Lawrence Police Department took 2 documents from the search, and it placed those documents into temporary evidence briefly, and then it placed them into its Spillman records management system. And there was some, I guess, unknown period, because we didn't have someone to testify about it, but there was some unknown period for not more than a day, but like where it was in that system, but the technicians for the Lawrence Police Department hadn't done what they needed to do to restrict access to only Agent Rob, who was the officer who was responsible for those.
Well, be that as it may, the Douglas County DA had a heck of a hard time finding anybody that could even take this case because they hadn't touched it before. Those are the facts, right?
Well, I don't know why we couldn't have another county assist us, or why they wouldn't agree to assist us. But I do know
if the court had ordered it, there wouldn't have been a choice.
Right. If the court had ordered it, I mean, yes, there would have been someone else.
But the court didn't order it, and I thought the record shows that your boss had a heck of a hard time finding anybody who could even do this case because they hadn't been involved in it.
Right. Sort of as an affirmative effort to try to take any precaution.
That's not a good sign, is it?
That no one else wanted to handle the case?
Practically no one in the office hadn't been involved in the case.
You're saying in an abundance of caution, people who had no knowledge of it chose not to have anything to do with it?
There was,
Or were there,
I'm
in fact, a lot of people had knowledge of it?
So the office didn't try to find someone else in its own, some attorney within its own office to handle the case. It was trying to find someone outside of its office as a precaution to avoid any issues. But once that it wasn't able to do that, there was no issue with finding an attorney who knew nothing about the case. And we know that the 2 attorneys who ultimately prosecuted the case knew nothing and weren't even around when the search events occurred.
Is the DA's office a law firm under
Yes.
our rules?
Yes, I believe so.
And those rules apply to the DA's office?
So the professional conduct rules apply to the DA's office. They say the DA's office should be treated as a firm, but they create special rules for government lawyers, like a DA's office. And those rules don't impute conflicts to the entire office. You know, they don't impute one lawyer's personal conflict to the entire office.
So there's a special rule under that if an attorney and you're the attorney next door, there's no imputation? What rule is that?
So comment 6 to rule 1.10 says that former client conflicts are not imputed to government lawyers associated with individually disqualified.
I'm talking about knowledge of information gained in the prosecution. Is that privileged?
Because we don't have a sequential representation. Former client doesn't squarely apply rules.
Right, and that's
1.10,
part of the
1.11.
arguments the government or the state has made, that those rules just simply aren't applicable here because that's not the proper framework for the remedy the district court had to, for the decision as far as what remedy the district court had to choose.
Well, if a public defender had obtained your confidential memo somehow in the case, would it be okay to just say, oh, we'll give this to another public defender in the office? Would that be a good enough remedy?
I mean, I believe that that's what the rules allow. Again, I think if in order for the state to have the entire public defender's office disqualified, it would have to prove that what the, what was required in this case, which is essentially that no prosecutor in that office could provide the state a fair trial. And that they were exposed, or there's some other circumstance that would preclude the court from finding there was going to be a possibility of a fair trial.
Your argument is that in 2007, the rules of professional conduct changed about imputed conduct to a government agency.
Yeah, if we're looking to the rules, I believe that the
That's
rules
20
change.
years, right? 20 years ago?
Yes, but the reason I brought that up in the brief is because most of the cases or all of the cases that Mr. Henry has cited predate that rule change. So to the extent they are discussing any of the professional conduct rules, they're not discussing the rules that apply to this case.
I'm interested in that second issue that raised by Mr. Henry, and that's the disqualification of his defense counsel. Is he, what's your view on this? What can we do about that?
Well, I don't think this court needs to do anything. I mean, that's the state's position. I think that part of the reason for that is that Henry hasn't cleared an important threshold in this case, which is that he hasn't shown he actually has a Sixth Amendment interest in the court having allowed him to keep Hall. And I think that's clear from the Supreme Court's case law, where it is said that the right to counsel of choice promises defendants nothing more than the fair opportunity to use their own means to obtain the counsel of their choosing.
The disqualification was based upon this belief that he could possibly become a witness because of this privileged material that the DA's office had access to, correct?
So
your office used it to disqualify your opposing counsel. That's kind of a clean sweep for you, isn't it?
So
you not only got privileged information, you used it to kick the attorney off.
So I believe I have 3 points to respond. First is that, again, in this context, the information we seized, well, the relevant issue was whether that information was protected by the attorney-client confidentiality privilege, not necessarily whether the evidentiary privilege for attorney-client correspondences or communications applied. But and I've already lost my train of thought, but I don't believe that there was
Well, let me ask you about the timing, which I think is relating to his question. At the point the state moved to disqualify Mr. Hall as Mr. Henry's attorney, had he already been named as a witness in a separate case filed against his client, Mr. Hall?
Yes, the state had filed the criminal solicitation charge against Henry in a new case, and its complaint named Hall as a witness. And I think I think it's important. So there was the potential that Hall was going to be a witness against Henry in the case. And there was also the potential that the state's, that the fact Henry had access, or the fact Hall provided Henry access to Abbott's personal information was something that he would need to defend himself for.
Two separate concerns.
Two separate concerns, yes. And I think the district court was justified in refusing to disregard those concerns and believing that the potential for those concerns was great enough. The potential for the unfairness to Henry and to all the parties in the cases was, and again, these were 4 cases the court had to consider, that all that was too much to risk leaving Hall on as Mr. Henry's counsel.
Is there anything else the district court could have done besides disqualifying the whole Douglas County DA's office? I mean, it took off defense attorney. It took the prosecutor off the case. It suppressed the evidence that was the investigator's report, the attorney-client protected evidence. And it said this person, the investigator who'd been involved in looking at the documents and also in prosecuting this case we're here on now, would not testify. So did they tailor tailor the remedy to the offense, or is there something more the district court could have done in between that and dismissing the whole county attorney office?
I don't believe there was anything more the court needed to do to satisfy the constitutional concerns here. Owing to
Did this man receive a fair trial?
the state's position is that he absolutely did receive a fair trial. And I think that's evident for a number of reasons. Mr. Henry has identified no instance where the record shows the state's prosecutors made unfair use of any confidential information. I know he's argued that there's a difficulty in proving that, but there are other reasons to believe it's not a problem in this case, because we know Nicholson didn't testify as the court ordered. All the evidence the state did use at that trial, or that another prosecutor could use at a retrial, pre-existed the state's intrusive conduct here. So it's not tainted by anything that happened. And that evidence incriminated Mr. Henry, to such a degree that, even had a different prosecutor presented it, beyond a reasonable doubt, the jury still would have convicted him.
Was the only reason the court didn't disqualify the DA's office is because you couldn't find anybody else to fill your shoes?
I can't speak to what was in the district court's mind.
Anything in the record that shows that?
I don't think there's any, it would be speculation to say that was what was in the district court's mind, because the record only shows that the state made an effort to try to find someone else. And
Did anybody ask the judge to recuse? Because by this time, the judge had access to all of this information, correct?
Correct. No, no one asked the judge to recuse.
Should we be concerned with that?
I don't believe so. I mean, I don't recall when Mr. Henry had new counsel and later filed a motion to dismiss the case. I don't recall exactly what materials the court may have reviewed in camera that might have exposed the court to confidential information. But we know that at least it saw the redacted Brunt report. And I don't believe there's any reason to suspect that the information that was in that unredacted information in that report.
Did the district attorney's office have an affirmative duty to protect this information, the confidentiality of this information?
I mean, the state had an affirmative obligation to respect the confidentiality.
And protect the information from dissemination?
Well, to protect the integrity of the case by not exposing the assigned prosecutors to the information, certainly. But it also had an interest in possessing the information because it was evidence of crime. And a crime that was very serious and almost jeopardy.
So that trumps the rules about confidentiality.
I think when a defendant uses information that might otherwise be confidential to commit a crime, the state has a right to gather that evidence to investigate and prosecute that crime.
Is that the attitude that was taken in the prosecution of this case?
Well, I mean, it was to the extent that the state filed charges and intended to introduce the evidence that Henry possessed Abbott's personal information. But I don't know that it has anything to do with the state's attitude with respect to how it prosecuted this aggravated robbery case. And I see my time is dwindling, so unless the court has further questions, I just ask that this court affirm the district court's judgments and affirm Mr. Henry's conviction.
Apparently not. Thank you.
Thank you.
You still have 3 minutes.
Thank you. May it please the court, there were 2 issues I wanted to just address in my rebuttal. First, the state had brought up how looking at the rules of professional conduct is the improper framework, that we should be looking purely at the Sixth Amendment. And I think, Judge Gardner, you kind of alluded to it. What U.S. v. Morrison says that after you found the violation of the attorney-client, basically the right to counsel, then it comes time to fashion the remedy. So ordinarily, we would just have the Sixth Amendment as our guide, but of course, we know that we can add to constitutional rights. And so once it came time to fashion the remedy, I think that's where Kansas law and around imputed disqualification comes in. It might not be part of the Sixth Amendment, but there's nothing that says when it comes time to fashion a remedy that you can only look to the Sixth Amendment.
So you're arguing a Sixth Amendment violation, but not the traditional Sixth Amendment remedy.
That's correct. And I don't believe that the state challenged the district court's framework for how it assesses whether there was a Sixth Amendment violation of the attorney-client relationship, kind of from like Weatherford versus Bursey and Morrison. So it's after what we're really discussing is whether the remedy that the district court fashioned was appropriate. And I'd say under Kansas law, it wasn't. Many other states and federal jurisdictions, we're only looking at Sixth Amendment cases, but here in Kansas, because we have the history of imputed disqualification, and even with that 2007 amendment, that still doesn't address the issue that we had here, because there is no ethical rule whatsoever. There isn't the sequential representation that Comment 6 would cover. What we're dealing with here is something entirely different from, a conflict to a previous client. We have an adversary obtaining confidential and material information, and there's nothing to suggest that that would have been affected by the change. And finally, just because the state brought it up, I would just ask it about the issue of whether Mr. Henry had a continuing right of representation by Mr. Hall. I'd say Wong is enough to say that we treat whether someone is appointed or retained. That's enough to do it. But if this court does have to wade into the question of whether a defendant who is appointed counsel has the same right of continuing representation by that counsel, I would ask this court to not take the state's path. I would ask it not to stratify the Sixth Amendment right to counsel based on whether a defendant is affluent and indigent. A defendant who is appointed counsel has the same right as one who retains counsel to have that attorney stay on unless the court has found a reason to disqualify that attorney. If there are no further questions, I'd simply ask this court to reverse. Thank you.
Thank you, counsel, very much, both of you, for your briefs and your arguments. We'll take the case under advisement and get a written decision out to you just as soon as we possibly can.